If you have just been in a car wreck, you are not just dealing with bent metal. You are dealing with a story that is about to get written for you. And the scary part is that the next 30 minutes matters more than the next 30 days. Because in this first half hour, people make decisions that quietly destroy their claim. Not because they're careless, but because they're shaken up, trying to be polite, trying to be tough, and just trying to get home. Hi, I'm Mama Justice, a personal injury attorney with years of experience, and today I'm going to walk you through the 5 biggest mistakes that people make after a car accident, especially here in Mississippi, and how to avoid them. But first, I want to give you a simple 3-step rule that you can remember even when your hands are shaking. Step 1, lock the record. Step 2, lock the medical timeline. Step 3, lock your words. If you do these 3 things, you avoid most of the traps that cost people money, time, and peace of mind. All right, let's get to it. Mistake number 1, leaving the scene without calling the police. This is the first mistake I see all the time. 2 drivers get into a crash, they exchange numbers, maybe take one quick photo, and then they leave. Sometimes the other driver even says, "No need to call the cops, we can just handle it ourselves." That sounds reasonable until it's not. In Mississippi, drivers are required to report certain crashes to law enforcement immediately, including crashes involving injury or death. And when the property damage hits a certain threshold, Mississippi Code Section 633411 lays out the duty to give notice by the quickest means of communication when those conditions are met. And even if you think the damage is minor, call anyway. Here's why. The crash report is your first piece of neutral documentation. It anchors the timeline, it locks in the location, the parties, and the vehicles, and the initial account. It also makes it a lot harder for the other driver to rewrite history 2 days later, because yes, that happens. I've seen it play out like this. A client gets rear-ended in Jackson. The other driver is apologizing at the light. Everybody's calm. They agree to swap information and move on. 2 days later, the client's neck and back tighten up. They call the other driver to get the insurance information. The other driver stops answering. Then the insurance company says, "We have no proof our driver was even involved in the wreck." Now, you are not just proving your injuries, you are proving the crash even happened. Also, Mississippi law expects drivers involved in a crash with injury, death, or attendant vehicle damage to give their information and render reasonable assistance. That duty is spelled out in Mississippi Code Section 633405 in plain English. You do not want to leave the scene until you have done what you are supposed to do and you have the record to prove it. Bottom line, lock the record, call law enforcement, get the police report. Let's get the paperwork to protect you in case you need it later. Mistake number 2, waiting too long to get medical attention. Mistake number 2 is just trying to walk it off. A lot of people in Mississippi are tough. They don't want to run to the doctor. They don't want an ambulance bill. They don't want to make a big deal out of it. But your body is not honest right after a crash. Adrenaline covers many things. Shock delays pain. And some injuries are sneaky. Whiplash, concussions, soft tissue injuries, back injuries, even shoulder and knee issues can show up hours or even days later. Insurance companies know this, and they use delays like a weapon. If you wait, they say, "If you were really hurt, you would have gone right away." If you wait, they say, "Maybe something else caused this." If you wait, they say, "You must have been fine." Here's a simple way to think about it. You need a clean medical timeline. The earlier you get checked out, the easier it is to connect your symptoms to the crash. That does not mean you need to claim injuries you don't have. It means you need to be evaluated and documented. If you're at the scene and you feel dizzy, nauseous, confused, or if you have neck, back, chest, or abdominal pain, do not debate it. Get seen. Even if you feel mostly okay, a same-day urgent care visit or ER visit can make all the difference between a smooth claim and a fight. And when you go, do this one thing that matters. Tell them you were in a car accident and describe every symptom, even if it's small. Do not minimize it. Do not joke it off. Do not say, "I'm fine." The medical record is going to be read by people who were not there. Make it clear. Step 2 was lock the medical timeline. This is what that means. Mistake number 3, talking too much to insurance companies. Mistake number 3 is thinking that the insurance adjuster is your buddy. They are not. Even the nicest adjuster has one job, to protect the company's money. They do that by reducing what they have to pay you. Sometimes they do it fairly, sometimes they do it aggressively, but they do not work for you. The biggest trap is the recorded statement. They call quickly, sometimes the same day, and they sound helpful. They say, "Let me just ask you a few questions. I want to get your side." And then they guide you straight into the landmines. Questions like, how fast were you going? Did you see them before impact? Are you feeling okay? Could you have avoided it? Were you distracted? And here is the part most people miss. In Mississippi, your compensation can be reduced by your percentage of fault. Mississippi Code Section 11715 is the comparative negligence rule that allows damages to be diminished based on the negligence attributed to the injured person. So, if the adjuster can get you to accept even a small piece of the blame, it can directly reduce the value of your case. That is why you do not guess. You do not speculate. You do not try to be fair. You stick to what you know, and you set a boundary. A safe script sounds something like this. I'm getting medical attention, and I'm not ready to discuss details. Please send these questions to me in writing. If I hire counsel, my attorney will contact you. You can provide basic identifying information and the fact a crash occurred, but do not give a recorded statement without legal advice. And whatever you do not say I'm fine. Say this instead. I'm still evaluating my injuries. That one sentence keeps you from boxing yourself in. Mistake number 4, not gathering evidence at the scene. Mistake number 4 is failing to collect the proof while it's still fresh. The scene is the one time you get truth before it gets cleaned up. Cars get moved, skid marks fade, debris gets swept away, witnesses drive off. The next day, everybody's memory gets fuzzy. If you are physically able and it's safe, here is your quick evidence checklist. Number 1, photos of both vehicles from multiple angles. 2, close-up of the damage. 3, license plates. Number 4, the intersection, lanes, and the traffic signs are lights. 5, debris, skid marks, and road conditions. 6, any visible injuries like bruising or abrasions. And 7, a wide shot that shows where the cars ended up. Then, get witness information. A name and phone number can change everything. Also look around for cameras, gas stations, traffic cams, businesses, doorbell cameras. You do not have to argue with anyone. Just note the location so your attorney can request footage quickly. Why does this matter so much? Because when fault is disputed, evidence becomes leverage. And when fault is shared, it becomes expensive. Remember what we said earlier about Mississippi comparative negligence? If you cannot prove what happened, the other side will try to split blame. Even a small percentage can reduce your recovery. One more evidence mistake that people make in 2026, they post about the crash. Do not do it. Do not post the photo of your car. Do not post I'm okay. Do not post gym selfies a week later with a caption about getting back at it. Defense attorneys and insurance companies look. Keep your case off the internet. Mistake number 5, accepting the first settlement offer. Mistake number 5 is the one that closes your case forever. And this is why you need to hear me clearly. The first offer is usually not the real offer. It is a quick offer. Insurance companies know you are stressed. They know the tow bill is coming. They know you might miss work. They know you are already getting calls and paperwork. They know you want this to be over. So they offer a number that feels like maybe relief. But here's what that check usually does not cover. Future medical treatment, specialists and imaging you've not had yet, physical therapy that may last months, lost earning capacity if your injury lingers, pain and suffering, the hassle factor of having your life disrupted, and the most important part, the release. When you accept a settlement, you usually sign a release that says you are done, even if new symptoms appear later. That means if your back turns into a herniated disc situation 6 months later, you do not get to reopen your case. This is why timing matters. You want to understand your injuries before you settle. Also, do not confuse the deadline to file a lawsuit with the right time to settle. In Mississippi, the general statute of limitations for many injury claims is 3 years under Mississippi Code Section 15149. That does not mean you should wait. Evidence disappears and leverage drops the longer you delay. And if your crash happened across the state line, deadlines can be different. For example, Louisiana just moved to a new 2-year prescriptive period for actions under the Louisiana Code, effective July 1 of 2024. So, where the crash happens matters. The point is not to turn you into a lawyer. The point is to keep you from signing away your rights because you were pressured. If you get an offer quickly, your default move should be this. Pause. Get medical clarity. Get advice. And then decide. Quick recap. Let's lock this in. The 5 biggest mistakes after a car accident are: 1. Leaving without calling the police and locking in the report. 2. Waiting too long to get medical attention. 3. Talking too much to the insurance company, especially on a recorded statement. And 4. Failing to gather evidence while the scene is fresh. 5. Taking the first settlement before you know the full damage. And remember the 3-step rule. Lock the record, lock the medical timeline, and lock your words. Now here's what I want you to do next, because even if you avoid every mistake I just listed, there's still a bigger game happening behind the scenes. In the next video, I break down what your insurance company does not want you to know about your claim. The scripts they follow, the delays they use, and the exact moments they try to get you to settle cheap. If you want to protect your money and your future, watch that video next. It's the difference between being managed by the process and controlling it. Click the next video on your screen called What Your Insurance Company Doesn't Want You to Know About Your Claim, and I will see you there.